I'm John Leonard. I'm a corporate lawyer at Fairfield and Woods in Denver, Colorado. We've done a series of videos that we have up on our website. Would invite you to review those, look those over. A lot of those have to deal with issues that come up with businesses. And whether it's raising money or what type of entity to choose. We have an employment law section, how to hire people, how to fire folks, how to wrap up your business. And we have one on trust and estates that's very good for business owners. Today, we're going to talk about receiverships with my partner, Jack Tanner. Jack, you have a interesting litigation practice. I know you do a lot of intellectual property litigation, general litigation, but one niche that you have and you're fairly busy with is receivership. So thanks for joining us and sharing this niche that you've built over many years. What is a receivership and how does it differ from bankruptcy?
Well, on the first question, what is a receivership? It's a very old method of fixing a broken company. Receiverships actually go back to England in the 1600s, where the origins of receiverships. But basically, when somebody's a creditor, a secured creditor, or an owner of a business, and the business isn't working quite right, and you want to get some court supervision, one of the ways you can do that is get a receiver appointed by a judge. It differs from bankruptcy in some ways, sort of analytically. In a bankruptcy case, you've got the bankruptcy code and you've got a trustee that's appointed by the U.S. trustee, and there's a lot of structure. A receivership is actually an inherent power of a court in equity. So there's virtually no statutes that talk about receiverships. It's just all common law. Judges think, hey, this is the fair and right thing to do. And that's the origin of receivers, and that's still the way receiverships work today.
So let's back up. You said a lot of things there. Is a receiver appointed by the court, and who could ask a judge to appoint a receiver?
Yes, a receiver is appointed by the court and reports only to that court. So there's no executive branch or legislative branch involvement. The receiver is an arm of the court, and there's two interesting issues about that. One is who can get a receiver appointed might be somebody that's a minority owner of a company and the company's not being run right. It might be a secured creditor of a company. In a stretch, a general unsecured creditor could if there's real fraud going on, but it's usually an owner or a secured creditor. But one of the interesting things about receiverships and their flexibility is anybody can be a receiver. I mean, when you go into bankruptcy, the U.S. trustee appoints a bankruptcy trustee who's usually a bankruptcy lawyer. In a receivership, if you got a receivership for a widget company, you can find some guy that used to be in the widget business and make him the receiver. And if the court accepts that, nominates your guy, then you've got somebody with real business understanding and business knowledge and experience running the company as opposed to a lawyer.
Now, this is interesting. If I'm a secured creditor and I'm not getting paid, I can foreclose and take those assets. But might it be better for me to get a receiver appointed instead of foreclosing on the loan and taking those assets?
It might well be, because often when you do a foreclosure sale, it's a fire sale. You get rock bottom price. You may not get your debt covered. Whereas you get a receiver appointed, the receiver may well be able to operate the company as a going concern and either sell it as a going concern or at least bring in new capital. And either way, a lot more money both for you and for any other creditors out there, which there often are. It's usually not just one creditor not getting paid.
If I'm a lender, can I put into my loan documents that I, as the lender, have the right to go into court and get a receiver appointed? And I don't know how that works. Do you have to post a bond or anything like that? Or?
Bond's optional with the court, but I will say almost every commercial deed of trust has that kind of provision.
For real estate.
For real estate. And those are always enforced by the courts. And a lot of asset-based lenders don't put that in their loan documents. And for the life of me, I've never figured out why. Because the fact that the real estate's not going anywhere. But if your lien, your security is on personal property that can be trucked away or whatever, I think it's more important you be able to go into the court, maybe even ex parte, And I don't quite understand why lenders don't put that in their loan documents.
Well, if a lender wants that in its documents, does it have an unfettered right, or does it have to be reasonable, or it still needs to go through the court to get the receiver appointed?
It does, but if the documents, just like in the real estate context, if the borrower consents to ex parte appointment,
What is ex parte?
just without, you don't have to notify the debtor. You can just go into court, get the receiver appointed, and the debtor only finds out what's going on after the receiver's already in place. Those are routine in commercial real estate, and they're rare in asset-based lending. And as I said, I don't quite understand why. I will say this, if any of your asset-based lenders and you want to put that in your documents, give me or John a call and we can help you do it. And I think your security would be a lot more valuable if you had that right.
Well, great. We'll talk about what a receiver does in our next video. And we hope you tune in.